On the record in docket 23-00100, Tyshawn Hickson, People versus Tyshawn Hickson. Will the parties please introduce themselves for the record?
Jessica Shaw, on behalf of the people.
Good afternoon, Your Honor. Attorney Derek Best, Office of Public Defender, on behalf of Mr. Hickson, who is seated to my right.
All right, and if I remember correctly, we were going to appoint or we were going to seek a Fifth Amendment counsel for a witness in this proceeding. So how are we going forward today?
Your Honor.
Your Honor, go ahead.
You can go ahead.
Your Honor, it is my understanding that Mr. Matt Samuels was appointed as counsel, and after consulting with him, the witness has decided that he would take the fifth if he were to be put on the stand as a witness today. And so given that information, Mr. Etheridge has decided that they would be waiving the exam today.
All right, and so Mr. Etheridge, is that a full and accurate statement concerning the events that have taken place?
Yes, Your Honor. However, it's my understanding, and I would like, and Mr. Samuels would like to call Mr. Kajar up to the stand and have him invoke the fifth. So we have a record of him invoking the fifth, and then after that, we would just waive to go to circuit court.
There's no jury here, so I don't think there's, but I think if you would like to proceed that way, I have no objection to that. So,
Yes,
and Mr. Samuel, you were appointed to represent the witness in the case.
That is correct.
And to explain to him the Fifth Amendment. So your appearance for the record.
Matthew Samuels on behalf of the witness, Cameron Kajar.
All right. And would you like to proceed by calling the witness in order to confirm what we've discussed here today?
Yes, and to put it on the record that he will be invoking his right to self-incrimination.
All right.
Self-incrimination.
Any objection to that, counsel?
No objection.
All right. You may proceed. All right, so I'm going to go ahead and swear the witness in. Sir, I'd have you come up here, right up here. Can you stand right in front of me? Please state and spell your first name and your last name.
Good morning, Kajar, K-A-M-A-R-E-O-N-C-A-J-A-R.
Okay, C-A-J-A-R. Okay, raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury? Right. You know, if you sit here, Mr. Samuels, you may proceed.
Mr. Kajar, it's your understanding that you would be called as a witness? And do you plan on, and you're aware of what testimony would be towards? And you do plan on invoking your Fifth Amendment right against self-incrimination at this time? And that was a decision you came up on your own? I have no further.
And that decision was based on your meeting with attorney Mr. Samuels concerning all of these events. Okay. Any questions?
No, Your Honor.
Just one, Your Honor. And he said it's kind of broad in the areas that you would be questioned on. I would be questioning on possession of a gun, correct? And you would plead the Fifth Amendment to that questioning, correct? Thank you, Your Honor.
Okay, with nothing further, may this witness be excused from the people?
Yes, Your Honor.
From the
Yes.
defense?
Yes, Your Honor.
Sir? Mr. Samuels? All right, this witness is excused. Thank you, Mr. Samuels.
Thank you, Your Honor.
So it's my understanding, Ms. Shaw, that and Mr. Etheridge, that the defendant, Mr. Hickson, wishes to waive his right to preliminary examination today, and then negotiations are going to continue in circuit court.
That's correct, Your Honor.
Mr. Etheridge?
Yes, Your Honor, that is correct. There was a preliminary plea offer. I don't know if the court wants that on the record or just negotiated circuit court.
If there's an offer and you'd want it, I can write it down for the court.
The offer would be to plead to count one with no objection to HIDA status. and further negotiations to continue with regard to sentencing.
And that's my understanding of the agreement as well, Your Honor, and I've discussed that with Mr. Hickson, and he understands it as well.
All right. So the offer at this point in time is plea to count one. HYTA status is Killebrew, and negotiations are continuing in circuit court. Is that my understanding?
Yes, Your Honor.
All right. May I inquire of your client of his Fifth Amendment, of his waiver of the preliminary examination?
Yes, Your Honor.
All right, Mr. Hickson, you can stand for me. All right, you understand you have the right to a preliminary examination today. It's a probable cause hearing in district court. Do you understand that, sir?
Yes, sir.
Okay, and the probable cause, that preliminary examination means that the people would have to prove by probable cause evidence that a crime was committed, and by probable cause evidence of the identity of the person who committed that crime. Do you understand that, sir?
Yes, sir.
You, of course, are represented by Mr. Etheridge. He would be here to contest any charges and cross-examine any witnesses brought against you in this felony matter. Do you understand that?
Yes, sir.
It's my understanding today that there is an offer out there. It's pleads to the charge with YTA status, and negotiations are to continue at this point. But it's my understanding that you're wishing to waive your right to a preliminary examination today. Is that correct?
Yes, sir.
All right. Do the people waive their right to a preliminary examination?
Yes, Your Honor, but just one clarification, it is no objection to HIDA.
Okay, no objection to
Yes,
it.
sir.
Okay. What I probably said Killebrew,
Yes, Your Honor.
which is a difference. Yes. So is that your understanding, Mr. Etheridge?
Yes, Your Honor, with
Right.
that correction, it is.
So right now, if you waive your right to preliminary examination, we won't have that. We won't have it on any preliminary examination. We'll go to circuit court where the trial court is, and your time in district court will be done. Do you understand that, sir?
Yes, sir.
It's my understanding that the offer at this time is to plead to count one, and the people would have no objection to YTA status. Is that your understanding?
Yes, sir.
All right. Is it your intent today to waive your right to preliminary examination here in district court?
Yes, sir.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. People also waive their right to preliminary examination?
Yes, Your Honor.
All right. And so I will bound this over as charged to circuit court based on the defendant's waiver. Your time here in district court is done. Any new date you get in circuit court will come from Mr. Etheridge, your lawyer, okay? Because we don't know what it is yet, but when you get it, that's where you'll hear from, okay?
Yes, sir.
All right, anything else for the record or on the waiver in regards to docket 23-00100, Ms. Shaw?
No, Your Honor.
Anything, Mr. Etheridge?
No, Your Honor, other than we'll sign the waiver document
right.
after we get off the record, or now if the court prefers.
It doesn't matter. We'll put it on the record. Yeah, we sign it, and then I'll sign it on the record. We'll be done.
Thank you, Your Honor. You and I both have to sign this as well as the prosecutor. and I'll take a second. This is just in writing what we just did on the record.
Again, Wendy. Because we closed it down.
You're signing that?
Is there a place on that old form?
Yeah.
Is there?
It's right below where you and I signed.
There's two forms out there, and one has a place for your signature and one does not. Right, for the record, I'm signing the bind over. You're all set here in district court, Mr. Hickson. Good luck in circuit court, okay?
Okay, thank you.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Etheridge.
Yes, sir.
And then Mr. Jackson's not till 2:30, but we can bring him up when you're ready and Mr. Sartz is ready, and however you want to proceed on that.
Thank you.
Huh? Oh, that's right, Miss Murphy's on that case.
Ms. Murphy is, I just want to make sure that she's here before I.
All right, don't worry about it. You did. I forgot that was her case.
Yes.
Oh, okay. Perfect. Thank you.
I only worry about the search warrants. I can always call my wife.
And they're still here. Or that.
In general, open files.
Oh, I don't know, open files.
He only has one open, but he has the cards on his circuit.
He's got something circled already.
He should have the 19 cases, probably 19th delivery charge. 19.
I'm just curious, 'cause I know I've seen them.
Weapons, drugs, weapons. He's got a long history.
Did you get some lunch?
I did, I had my soup.
Daniel, did you get some
I
lunch?
did.
I had all the, yesterday rescheduled, Daniel, because he's a nice person, got everything mailed. He did the origami.
So there, how many cases was that?
There's more than I thought there was, I'll say that. I
Yeah.
didn't think there was as many as.
I think they're like 25 or 26 or something.
It seemed like a lot when I was scheduling
Mm.
them, but scheduling in civil is extra steps like scheduling in criminal, and
The only attorney that had an issue with the 15th day was Mr. Pfeiffer, so we set those up 22nd
That's
at his
fine,
request.
I don't think everybody experienced the same thing, which is nobody wants to go outside and drive.
One pro per asked for an earlier date. I said that we didn't have an earlier date,
Right.
15th. The
Yeah.
next day was April 19th.
Yeah, take the 15th.
Yeah.
That actually, well, we'll see how the 15th looks, but that actually went pretty smoothly, considering that we were moving an afternoon docket.
yeah, and we have like a bench trial, 2 jury trials, and a couple motions that morning, so I just started the LT pre-trials. I checked in with Danielle and we decided 9:30.
That's fine. The civil trials rarely go.
This,
May, bridge trials occasionally go, but,
the bench trial is out pro per, so who knows?
well, then it's likely to go and be a complete train wreck, but that's just the way it is.
I gave it a half hour for the train ride.
And I sent an email regarding the civil case tomorrow that they wanted canceled.
Yep.
I haven't gotten a response yet.
Well, if nobody shows up, nobody shows up.
And it's a motion. I don't think they have to send in a dismissal. I think they just needed to let me know if they actually wanted the hearing canceled.
Right. But she kind of did that, didn't she?
And yeah, I said I am writing this to express my interest in canceling this case scheduled for
Yeah.
Friday the 24th. So
I get,
I
you can,
just-
we can take it off, I mean, and you can indicate we're taking it off until we hear further from you, you know. I mean, it'd be different if it was the defense seeking it, but it's the moving parties on their own motion is, you know. in docket 22-03542. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Crystal Murphy on behalf of the people.
Good afternoon, Your Honor. Jacob Starks, the fourth Assistant Public Defender here on behalf of Mr. Jackson. Mr. Jackson's at council table. He's standing to my right.
Okay, and sir, you are Savan Jackson Jr.? All right. This is the time set for preliminary examination or continuation of our preliminary examination that was previously started on January 20th. We had several adjournments and a motion in between. We're back on the record for a continuation of the preliminary examination. How would people like to proceed today?
Thank you, Your Honor. The people are ready to proceed. It would just have a few brief preliminary matters if the court would allow.
Sure.
Thank you, Your Honor. The people would move to admit people's marked exhibit 1 and 2 into evidence under MCL 76611B. It's the drug lab and as well as the certified copy of conviction from the clerk of the Circuit Court of Cook County.
And I believe they have already been admitted, but just in case they had not, and there was no indication that we'll readmit them again.
Thank you, Your Honor. Also, Your Honor, I'm sure this was probably previously mentioned on the previous record, but the people are looking to add 3 counts of felony firearm to correspond to each one of the charge counts, the complaint and warrant. The PAT code for that is 750.227, B as in boy, dash A as in apple.
I don't know if Mr. Wisty indicated that in the initial prelim, but I'm certain that that's been a subject of conversation. I'm trying to think if that in my notes reflect, and it was Mr. Wisty originally, wasn't it? And
Correct, Your Honor.
then it was Miss Gallagher, and then it was yourself. So, all right. And you can indicate the same for anticipating bind over. You can make the same argument for bind over. And then if we haven't already, so exhibits 1 and 2 are admitted through stipulation. Is that correct, counsel?
Well, Your Honor, they've been proposed. I'm not going to, in terms of the previous conviction, that appears to be a certified copy. So at this point, I don't think I'd have a basis for an objection.
Right.
As for the lab results, those were ultimately turned over to me. I did receive a copy of them. They were received through the course of the chain of discovery, and based on the statute, the prosecutor is not required to produce a witness who can testify to the foundation for that. So I don't think I would have legal grounds to object to it.
All right. So without objection, then
Thank you.
exhibits 1 and 2 are admitted into evidence,
Thank you,
and
Your
they may
Honor.
have been previously admitted. I just wasn't sure.
Thank you, Judge. And also, it's my understanding that the people's proofs were closed when the exam initially began, and I would just ask for permission to reopen proofs and just ask maybe a half a dozen or so questions. I'll be pretty brief.
I have no objection to that, counsel, and he's going to be on the stand anyway for cross-examination.
That's correct, Your Honor. At this point, I don't think I'd have a basis to object to that at this stage.
All right.
Thank you.
So it's Detective Dykens, right?
Yes, sir. I'm not a detective anymore, but I'm out of the unit.
All right. So for our Officer Dykens, you can come up and
Your Honor, I'd also just ask for the standard sequestration order. I don't think that's gonna be
Absolutely.
an issue here, but
right. So I'll leave it to counsel. Let me know if anybody comes in that may be a future witness. Other than that, right now, I think we're good, but you'll know if you see somebody that could be a potential witness, and then we'll invoke any sequestration order.
Thank you, Your Honor.
Thank you, Your Honor. Just for purposes of the record, there's just 2 prosecutors in the courtroom right now, and that's it.
Okay. All right. So Officer Dykens. So I'm gonna have you stand right here again and state your full name and spell your full name for the record.
Darren Dykens, DarrenDykens.
All right, please raise your right hand. Do you solemnly swear or affirm tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, have a seat there. Please project to the back for recording purposes, and you may proceed.
Thank you, Your Honor. And I just want to make sure I know you were detective at the time. Is it sergeant now?
Yes.
Okay, Sergeant Dykens, good afternoon. I just have a few questions for you. Were you involved on a raid on a location on June the 7th of 2018?
Yes.
All right, and was that particular address 1026 West Edgewood Boulevard?
There's additional, but it was at 1026 West Edgewood, yes.
Okay, and was that an apartment complex?
Yes.
Was it apartment number 3?
Yes.
All right, and were you the affiant of the search warrant on this particular raid?
Yes.
All right, and what gave rise to that particular search warrant that you were the affiant of?
It was a drug investigation that took place over a span of days with narcotics, controlled purchases that resulted in myself obtaining a search warrant for a residence.
All right, and that particular residence, I know you testified previously when the exam started. The investigation that you just testified about, was there a particular individual that was a subject of the investigation, a particular individual that you were investigating or that your team was investigating?
Yes.
Okay, and is that the individual that you identified as a defendant previously?
Yes.
Okay, and what significance, if any, did 1026 West Edgewood Boulevard, Apartment 3 have to you in your investigation?
That was where the defendant would come from a couple of times during the controlled purchases. And then there was one additional time that he had returned back to that residence. This was within the days of doing those controlled purchases at 1026 West Edgewood, Apartment 3 in the city of Lansing County, state of Michigan.
Okay, and was that defendant Steven Jackson?
Saban Jackson.
Saban Jackson, all right. And the day of the raid on that particular location, what happened?
I briefed the SWAT team with an ops plan. They executed the valid search warrant. After the search warrant was executed by the SWAT team and the residence was secured, at that point in time, Tri-County Metro Narcotics officers or detectives conduct a search of the residence. Within the scope of the search, we had located suspected heroin and a 9mm black handgun with ammunition inside the magazine well.
Okay, and that was inside of the gun?
That was inside of the gun.
Okay. Now, I know you testified about this previously, but you spoke with defendant, is that right?
Yes.
And did he waive Miranda?
I Mirandaized him and he had advised me that he understood his rights. At that point in time, Miranda was waived.
Okay, and when he did talk to you, he meaning defendant, I know this was testified about briefly, but what specifically did he tell you after Miranda was waived?
There was a couple questions I asked him, but specifically that I recall was that he was taking ownership for the firearm and the narcotics inside the residence, and that he would sell narcotics to make money.
Okay, and where in relation in the residence was the firearm and drugs found?
They were in a bedroom. I cannot recall the specific bedroom, however.
Okay, with looking at a copy of your report, refresh your recollection as to the location of the narcotics as well as the firearm?
Yes.
Okay, Your Honor, may I approach with my computer, which has the report on it?
Correct. You may, as long as council gets a chance to look at what you're refreshing memory with.
Absolutely, Your Honor.
Pages out. Okay, thank you. Thank you, Ross.
You may proceed, council.
Thank you, Your Honor. I'm having a technical, no, not, never mind. May I have a brief moment, Your Honor? I'm having a technical
Sure.
issue. Did you see that?
I only saw one item. see the others still.
Okay, but the item that you did see, I'm gonna work on the technical issue, but the item that you did see, is your memory been refreshed as to where the location was?
For that specific item, yes.
Okay. What specific item did you look at to refresh your memory in the report?
The suspected heroin
Was where?
was in, what is it, southeast bedroom?
You're sure it was the seventh?
I'm sorry, the northeast bedroom.
Okay,
Yeah,
all right.
sorry.
And let me ask you this, before the execution of the search warrant happened at that location, did you meet up with any other troopers or officers that were part of the team?
Yes,
What, if anything, happened when you met up with those individuals?
I met up with Trooper Sweetite and Breslin, and they conducted a traffic stop on defendant and had turned over an amount of currency, US currency.
Okay, and do you recall the amount of US currency?
I don't recall specifically the amount of currency. I know it was a substantial amount for an individual to carry on his person, though.
Would looking at a copy of report refresh your memory?
Yes.
Page 6 and 17. Has your memory been refreshed?
Yes.
Okay, what was the amount of currency found on defendant?
$1,218 US currency.
Okay, and let me ask you this, Sergeant, how many years did you work on narcotics investigations?
I was in the unit for approximately a year and a half, but also before going into the unit, I did several narcotics investigations, which did also result in forfeiture of US currency.
Okay, and from your training and experience as a law enforcement officer, what, if anything, does that indicate to you, that amount of currency being on an individual?
I'm going to object on the grounds of calls for speculation, and further, he's not been qualified as an expert. Thank you.
Response?
Your Honor, I'm not attempting to qualify him as an expert, simply a training and experience as a police officer question. These are allowed, and he can testify based upon his training experience.
I'll take it as training experience. I don't take it substantively as an expert witness testimony.
Thank you, Your Honor.
Thank you. You may proceed.
Thank you, Your Honor.
Through my training experience, for an individual to carry $1,218 in US currency, along with conducting narcotics transactions, that would indicate that the individual, because he's carrying, he or she at the time, but for this case, he was carrying it in multiple denominations, that would indicate that there was narcotics that were being sold and purchased due to the fact that there was multiple denominations, excuse me. That is a indicator in itself that when someone is purchasing narcotics, they typically do it in multiple bills, depending on the amount that they're purchasing from their dealer.
All right, and how did that factor in, just taken into the account of the entire investigation of everything that you had mentioned about that was in your particular search warrant? How did that factor in based upon what you believed at the time and from your training experience?
I'm sorry, can you rephrase that? maybe?
Sure, absolutely. So based upon the investigation, the narcotics investigation that was going on, based upon that large amount of money, how did that factor in based upon your training experience of what that indicated to you?
Just the fact that they had that much money due to the fact that there was confidential informant narcotics transactions or purchases. Once we had seized the narcotics during those transactions, this was a clear indicator that the individual, the money that was on his person, would more likely than not had come from narcotics transactions. And coupled with the interview of him advising me after Miranda was read that he was trying to make money by selling narcotics.
Thank you, Your Honor. I have nothing further for this witness at this time.
All right, cross-examination.
Thank you, Your Honor. Sergeant Dykens, you testified earlier that there was some type of controlled purchases, some previous activities that went on prior to obtaining the search warrant, correct?
Yes.
Did you personally help facilitate those transactions? Did you work with the CI?
Yes,
Okay. Was the currency marked?
past practice, we would mark currency. I cannot advise specifically on this case.
Okay.
So I can't recall specifically for this case.
So they didn't find any marked currency to your knowledge when they did the seizure on June 7th, 2018, correct?
Not that I recall reading in my report.
Okay. And just so I understand the timeline a little bit clearer here, when did the search of the Edgewood property occur? About what time?
I believe it was on June 7th.
Okay. Do you recall what time of day that was?
I don't recall what time of day it was.
Okay. But you testified earlier that you talked to Mr. Jackson, correct?
Correct.
Do you recall what time that was?
I don't recall a specific time.
Okay. And could you describe the conditions of Mr. Jackson and the location where you claim that you talked to him?
What do you mean by conditions?
Sure. Where was he?
In my presence?
In your presence, where?
I can't recall exactly where we were at when the interview was occurring due to the time frame here.
Okay. Do you recall his physical condition?
Sir, this was so many years ago, I can't recall.
Sure, that's understandable. Did you ask for identification from him?
He was identified through an Illinois license.
Okay, so he had an Illinois address, Illinois license, correct?
It was an Illinois license.
All right. Did you talk to him inside of, where do you recall talking to him?
I can only go off of what I read in my police report. I know that an interview was conducted. I don't recall exactly where we're at, sir.
Okay. But do you recall the type of location? Was it in a car? Was it in an open air environment? Did you recall any details about where you claim you talked to him?
I don't recall, I'm sorry.
Okay. To the best of your recollections, did Mr. Jackson ever request a lawyer?
I don't recall specifically this case. I know through my training experience, if someone had requested a lawyer, though, I would stop questioning.
Okay. And you testified earlier about your experience in training, correct?
Yes.
So to the best of your knowledge, with Tri-County cases, they were supposed to be working microphones, cameras inside the patrol cars, correct?
I am not a part of Michigan State Police, so I cannot answer that question.
Okay. Well, what about your experience in training as an LPD officer? Back in 2018, at the time, were you supposed to have working and functioning body cams?
In what capacity?
Well, specifically, did you record the alleged interaction that you had with Mr. Jackson?
To my knowledge, again, I'm basing this off of my police report, sir. So if there's no recording in the police report, then I would say that there's no recording. It would be an officer safety issue for any type of body camera footage for an undercover officer to wear that. Regardless,
Okay,
if we were in a vehicle, it doesn't matter where we're at. If someone was to be driving around and see an officer with a body camera on, take a photo of that undercover officer, that could potentially harm me in further encounters. And I have to get home to my family, sir. So,
Oh, sure, that's understandable. But to clarify, were you undercover at that point, or were you in a uniform when you helped conduct the search?
I was working in an undercover capacity.
Okay. But there were other officers with you who were in fully marked vehicles and other officers who were performing in their official capacities now, correct?
I recall meeting with troopers Sweetike and Breslin that had conducted a traffic stop. Those are the only marked officers or troopers that I can recall.
Okay, so they conducted the traffic stop, correct?
Correct.
To the best of your knowledge?
Yes.
And you at one point ultimately met up with them, correct?
Yes.
Okay. And do you recall when you met up with them?
would believe it's after the traffic stop, because that's how they got the currency, and that's how I got the currency.
Okay. And based on your training and experience, were you aware at the time that MSP had body cams, or not body cams specifically, but cameras and videos in their cop cars?
Your Honor, I'm gonna have to object as to personal knowledge. The witness indicated that he had not worked for MSP, I believe, and in terms of what their practices were, body worn cameras, dash, anything like that, he's not gonna know.
I think it's a fair question, so I'm gonna overrule the objection. If you know, you can answer it. If you don't, you can't.
I do not work for the Michigan State Police. I work for the city of Lansing. I cannot give you an accurate answer as to what type of equipment that they utilize in all of their motor vehicles.
Thank you. But you testified earlier about your training experience, and you understand the significant importance of a Miranda interrogation, correct?
Absolutely.
You understand that Mr. Jackson has his rights, including his rights to request counsel during that interrogation, correct?
Yes.
So even though you understood the seriousness and magnitude of that questioning, to the best of your recollections, your actual questioning of Mr. Jackson was not recorded, correct?
To my recollection, sorry, I can't talk today. No, not that I recall that it was, no.
Okay. So, and you don't recall the location as to where you questioned him, correct?
I believe last time I testified, I said it was like within the vicinity of being in that area.
Okay. And in terms of the house itself, you helped participate in the search of the house, correct?
Yes.
Did you find any mail or address information addressed specifically to Mr. Jackson at that address?
I do not recall finding something like that.
Okay. You testified earlier about finding the handgun,
Yes.
correct? Where was the handgun located?
I believe it was in the northeast bedroom.
Okay. And do you recall what type of clothing was located in that bedroom?
I do not know.
Was it perhaps children's clothing or female clothing, or
I have no idea.
was it, what type of bed was in that bedroom? Do you recall the type or shape, or
The type of what? I'm sorry.
what type of bed was it? Was it a king size? Was it a queen size?
Sir, I don't recall.
Was there a wardrobe?
I don't recall.
Okay. What about personal effects? Was there, say, a dresser with personal items?
The only thing I recall about the bedroom is that when I located in there.
Okay.
Yeah.
But you don't recall specifically where in the bedroom you found the item, correct?
No.
Okay. And what about the alleged narcotics? Where do you claim that you found those items?
My police report had indicated a shelf in the northeast bedroom.
Okay, northeast bedroom. So was this in a different bedroom than from the alleged firearm, correct?
I had told you the northeast bedroom prior, so no. I believe it was the same bedroom.
Same bedroom? Okay,
I believe so.
same bedroom? All right, so you don't recall finding any personal effects related to Mr. Jackson in that bedroom, correct?
No, not that I recall.
And you don't recall finding any personal effects, any address information, any mail relating to Mr. Jackson in the house either, correct?
Not that I recall.
Okay. And in terms of the firearm, the alleged firearm that was seized, that was not registered to Mr. Jackson, correct?
I would have to look at the file on the gun registration. I don't recall. I did not look at that today.
Okay. And was Mr. Jackson the only male that you had observed leaving the house, or were there other males that had visited the house during that period of time? Do you recall?
What period of time are you
Sure.
referencing?
My apologies. Let's go back to what led up to the request for a search warrant. Okay, you described that there were several controlled purchases.
Yes.
Okay, and the house had been under observation, correct?
Yes.
Okay. Did you recall other males entering or leaving the premises besides Mr. Jackson?
I don't recall other males.
Okay, how about other females?
Yes.
Okay. How about children?
Yes.
Okay. So other people were able to go in and out of the house then, correct?
Yes.
And did you find address information for anybody else at that address?
Sir, I don't recall.
Okay. And in terms of the gun, to the best of your recollections, was it ever tested for prints?
I can't answer as to what Michigan State Police did with the testing of that firearm.
Okay, so was it,
I did not personally, that I recall, test anything for a print, no.
okay, so in terms of the items that were seized, could you please describe just the chain of custody as to what happened to those items after they were seized?
Absolutely. So standard practice is that after we execute a search warrant, there's a seasoned officer. I was a seasoned officer per the return tabulation. We would then take those pieces of evidence and I would take those to a disclosed location, which is secure for the Michigan State Police because it was their unit. And then I would lock them into a evidence locker. At that point in time, you know, they would be tagged in or marked as a specific item as to what piece of evidence it is. So I would have been, once I was a seasoned officer, I should have been the only one until, you know, it's transferred to the Michigan State lab. I should be the one that's touching or having custody of that actual piece of evidence.
Okay, so you handled then the facilitation from the initial seizure until it was dropped off at a secure MSP facility.
I would be seizing officer. I tag it in at a disclosed location, which is secure, that is ran by Michigan State Police. It's tagged in as evidence. It is then transported, you know, to the Michigan State Police laboratory.
Okay, so you wouldn't know, for example, that MSP came back with the lab results and showed that there were no latent prints connected to Mr. Jackson on that gun, correct?
If I had a chance to look at the report, I would know, but I don't.
Objection, Your Honor, is the personal knowledge. He didn't test it. He doesn't know about it. He doesn't have the personal knowledge.
So I guess he can say, I don't know I don't know.
Yeah, and I don't know, it's a fine response.
Yeah,
all right,
Yeah,
so-
I don't-
The objections overruled, but you can answer that. If you don't know, you don't know.
I don't know what Michigan State Police did. with-
Okay.
Yeah.
Okay. And in terms of the alleged narcotics, you did a field test, correct? A narc test, was that you or is that? someone
I
from-
did the field test, but there was multiple field tests, yes.
Okay. And to the best of your recollections, there were scales in the house, correct?
I don't recall. I would have to look at the police report, sir. I'm sorry.
That's okay.
Yeah.
Do you recall baggies? How about small baggies?
There was plastic bags that the suspected heroin was in.
Okay, but were there other bags inside the house?
I don't recall.
Okay, this was a house full of
It was a
children in it. Okay,
apartment.
apartment?
Yeah.
Okay. Approximately how big was this apartment, to the best of your recollections?
Enough for one male and one female and a child to live in.
Okay, so how many bedrooms were in this location?
Sir, I don't know.
Okay, how about a living room? Is there a living room in this location?
I would assume so if it's an apartment.
Okay. How many bathrooms?
I don't recall the number of bathrooms.
Okay. Oh, now just to clarify as well, when you're searching the property, you don't recall seeing Mr. Jackson at the location, correct?
Can you clarify what you mean by that?
Sure. When you participated in the search, after the search warrant had been approved and when you were participating in the search itself of the property, did you observe Mr. Jackson at the location at 1026 Edgewood Boulevard.
I'm trying to understand your question. So I think what you're asking me, if I can clarify here, is that while I'm searching, do I see him there?
Correct.
He was stopped on a traffic stop. He had left prior to the search from my recollection.
Did you observe him leaving the location?
I don't recall if I'm on the surveillance scene today. I recall that and what I mean by my answer is that previously I have seen him leave that residence. So I cannot testify to the fact that did I see him the day of the search warrant. Previous days, I do recall this occurring. I just can't recall if it was specifically June 7th when that search warrant was executed.
Okay.
Yeah.
Thank you for clarifying.
You're welcome.
No further questions, Your Honor. Thank you.
Redirect.
Just a few follow-up questions, Your Honor. Thank you. Sergeant Dykens, I know you testified about how it's an officer safety issue with undercover officers and how you don't wear body worn cameras with this type of operation, right?
That is correct.
Okay, so in this particular circumstance, you read defendant his Miranda rights and he waived those rights and you took that statement, obviously with no body worn camera on.
That is correct.
And you were a detective at that time?
That is correct.
And is it common for detectives to wear body worn cameras?
In an undercover capacity, no.
Okay, so when you were at that particular assignment, there's gonna be times where you took a statement from a defendant where clearly there was no body or camera, fair?
Correct.
And then in terms of defendant being at the location of the raid, he wasn't there because he was arrested, isn't that right?
I'm sorry, could you repeat that?
The defendant not being at the location of the raid, when you executed the raid on the house, defendant wasn't there because he was arrested by the troopers, isn't that right?
Previously, he was stopped by Michigan State Police. That's why when I was searching, I don't recall him being inside of the residence. That is correct.
Okay, and then in regard to the sightings of defendant leaving that address, that 1026 West Edgewood, was there ever a point in time where you determined the vehicle that he was driving?
Yes.
Okay, do you recall any information about that vehicle?
Yes, it was a black car, I believe a Pontiac, and the registration came back to defendant Jackson.
Okay, and would you, you're sure it was a Pontiac?
I believe so. If I could look at my report, I guess I could refresh my memory.
Okay, Your Honor, may I report, approach with the search warrant? It's page 4 of the search warrant.
With that understanding, you may approach to refresh the witness's memory.
I'm also with this.
Okay, in regard to the vehicle the defendant was driving, in terms of the details, what were they?
It was a Pontiac for this correct, a Grand Prix.
The very pre, okay. Your Honor, I have nothing further for this witness. Thank you.
Okay. Any follow-up regarding the redirect?
Just briefly, because this has been asked on redirect, did you take any pictures or did you document in terms of recording these alleged incidences where you saw the vehicle go back and forth?
Not that I recall.
Okay, so you're just relying on your memory and what was in the report. You don't have any additional pictures or anything like that?
So I'm basing this information, sir, off being the affiant of the search warrant and refreshing my from the search warrant, what I read yesterday.
Okay, thank you. No further questions.
Without any other questions, may this witness be excused from the people,
Yes, Your Honor,
from
thank
the
you.
defense?
Yes, Your Honor.
All right, witness, you're excused. Thank you for your appearance today.
Thank you, Your Honor.
And further proofs from the people.
No, Your Honor, people have no further witnesses to call today at exam.
All right, does the defense and the people rest then?
Yeah, the people do, Your Honor, yes.
And does the defense have any witnesses today?
None for today, Your Honor. Thank you.
Okay, thank you. Motion for bind over?
Yes, Your Honor, thank you. The people move for bind over as charged with the additional 3 corresponding counts of felony firearm to correspond with the count 1 PWID, count 2 FIP firearm, and count 3 FIP ammunition. The court received 2 exhibits, certified copy of conviction of the defendant's prior from Cook County Circuit Court in Cook County, Illinois, as well as People's Exhibit 2, the laboratory report indicating 27.46 grams of heroin from the MSP laboratory. The court received testimony on 2 separate days. Previously, as the court mentioned, from a separate prosecutor, and of course today for myself. There was testimony about a statement the defendant made to the witness who testified here today that the heroin and the firearm inside of the residence were in fact his. Testimony regarding the statement indicated that Miranda was waived, and defendant willfully gave those statements to the witness. In regard to the location of the search warrant, the witness was the affiant of the search warrant at 1026 West Edgewood Boulevard, apartment number 3, City of Lansing, County of Hingham. There were some controlled buys that were conducted. Defendant was developed as a suspect. He was identified by the witness here today. He was identified previously on a different record, but he was identified by this witness who testified here today. There was indications from the witness that the defendant was seen coming to and from that location in a particular vehicle that the witness identified as being registered to the defendant. With that, Your Honor, I believe probable cause has been established here in regard to count 1 PWID. The witness also identified as to a large number of currency that was found on defendant when he was stopped by the troopers, and from his training and experience, coupled with the investigation of the controlled buys, that is very much common for drug manufacturing, drug selling, things of that nature. As well as the firearm and the ammunition located within that firearm. There was additional testimony that that firearm was in fact loaded. The firearm and the narcotics, the heroin, was found inside of that 1026 West Edgewood Boulevard apartment that defendant was seen coming from during the course of the investigation, and of course coupled with the statement that police will believe we've carried our burden as to probable cause based at this stage, and would ask for bind over on counts 1, 2, and 3 with additional added counts of felony firearm, which would be a grand total of 6 counts. Thank you.
And the 4, 5, and 6 felony, each one of those felony firearms are related to count 1, the delivery, count 2, the prior possession of a felon for a prior offense, and count 3, which is a possession of a felon for a different offense, as I see it.
Correct, Your Honor.
Okay. Response?
Thank you, Your Honor. Respectfully, on behalf of Mr. Jackson, I would request that the court dismiss the charges against Mr. Jackson based on the people's failure to present sufficient evidence for bind over on the respective counts for the added or requested counts as well. The basis for this, Your Honor, is certainly due to the serious credibility issues with Sergeant Dykins, whose memory obviously has been eroded substantially from the passage of time here, and could only recall scant details based on having been refreshed from what was in his report. He could not remember a lot of the most rudimentary or basic details. Important questions such as where was Mr. Jackson questioned? He couldn't remember that. And the list goes on and on. And further, Your Honor, I have serious doubts about the credibility of regarding Mr. Jackson's alleged confession based on all the inconsistencies and the lack of memory of Sergeant Dykins. And further, Your Honor, certainly, and this has been the subject of a lot of litigation, which Your Honor has already ruled on, but discovery is still an ongoing concern here. The age of the file is still an ongoing concern here. A lot of those issues have been preserved by motion practice, but they still, and this is why we have such large problems when a case like this gets reissued after all these years. It's because of issues like this where clearly the impact of time has eroded the witnesses' memories. Clearly, there's questions about the credibility, what they can testify to now. Here we are all these years later, And at best, we're stuck with these very limited items that can be used to refresh on. And while technically this case is within the statute of limitations, I of course have briefed, and Your Honor has already ruled that there was no speedy trial issue here, but nevertheless, you see the impact that it has on the credibility of the witnesses moving forward. Further, Your Honor, even if taken in best light towards the prosecutor, there are still massive holes here in terms of the actual evidence that connects Mr. Jackson to the alleged narcotics and the alleged guns. There's no additional testimony that connects him to that address other than simply Sergeant Dykins claiming that he had observed him going back and forth a few days prior and referring a CI alleged transaction. But Detective Dykins also testified they never recovered any buy money. There's no pictures or any other additional evidence that's been produced that's going to corroborate Detective Dykins' version there. And in terms of his recollections, he made it pretty clear that this goes back to what he claims was in the search warrant, and then also based on what was in his reports. So his recollections obviously have been substantially impaired here, and there's questions about his credibility as it relates more directly to connecting Mr. Jackson to the alleged firearm as well as the alleged narcotics. So, Your Honor, there's a lot here, but respectfully, there is not enough credible evidence here for bind over on these respective charges, and I would request that this court dismiss the case against Mr. Jackson.
Thank you, Mr. Swartz. Response?
Thank you, Your Honor. Just respectfully, the people would submit to the court that there has been sufficient testimony to bind over on each count, including the 3 corresponding counts of felony firearm. The arguments that counsel makes are a great argument for a trier of fact. They're a great argument for a trier of fact in circuit court if he wishes to file additional motions in regard to his arguments that he's made here today before this court. Certainly can in circuit court. I'm sure he will do that. In regard to the testimony, the defendant says that the drugs and the gun is his. In terms of identification, we have venue. In terms of probable cause, Your Honor, I believe the people have met every element based upon probable cause. And yes, there will be additional arguments and matters that will come up in circuit court. But with that, Your Honor, I would just respectfully move for bind over.
Thank you. Well, this is a fairly straightforward case, but it's got a long history, and it's got there's a lot here for what seems to be factually a case that is fairly straightforward, but it was issued and then reissued. I will indicate this is a probable cause hearing, probable cause being the second lowest standard in criminal law. The only lower standard is reasonable suspicion. So with this lower standard, I believe the people have met a probable cause level as to count 1 based on both exhibits 1 and 2, 1 being the prior felony conviction. We'll talk about that into counts 2 and 3. And then the testimony considered that this was heroin. It was 35 grams of heroin that came from the first preliminary examination, 35 grams of heroin that was admitted to by the defendant. The counsel brings up multiple points concerning credibility and concerning things that a trier of fact may take into account. Of course, at a probable cause level, I believe that it's sufficient evidence at a probable cause level to meet this lower standard. So the controlled substance delivery manufacturer at less than 50 grams is met by probable cause evidence that on or about June 7th, 2018, the city of Lansing at Edgewood Boulevard, count 1 is met by probable cause evidence through the testimony of the detective, now the sergeant, Mr. Dykins, Sergeant Dykins. In count 2, there's based on the second exhibit, which is admitted. I believe it was admitted the first time. It's also admitted at the second today at this preliminary examination of February 23rd, 2023. That the weapon that the defendant was a possession by a felon because of a previous conviction. He was not admissible to have a firearm on his person or to be in control of a firearm. So counts 2 and 3 are met because of the prior record. There's both indicated by the prior exhibit. The several counts that were added our felony firearm counts, they're counts 4 as to 1, count 5 as to 2, as count 6 as to 2, that there's probable cause to believe that the defendant was in possession of a firearm during the commission of a felony. The 3 felonies previously indicated are the narcotic of a heroin, the possession of a heroin, possession of a felon in front of a firearm in count 2, and possession of firearm by a felon in count 3. Counts 4, 5, and 6 are added and are sufficient for bind over based on the officer's testimony. That gives rise to a probable cause level. I'm gonna refrain from indicating what the trier of fact or how they would view this evidence if in circuit court. All we deal with is a probable cause level, and I believe that the people have established all 6 counts at a probable cause level. So I'll bind it over on the first 3 counts, and then the requested for counts 4, 5, and 6 of the 2-year felony firearm to add 6 counts to be bound over to circuit court for trial in this manner. Anything else? So the motion's granted. This will go to circuit court. Your time in district court is finished now. It's bound over to circuit court on the 6 counts. Anything else for the people in this matter?
No, Your Honor, thank you.
Anything else for the defense, Mr. Sars?
Thank you, Your Honor. Nothing further. We've requested the transcripts.
All right, thank you. With that understanding, that's all for the record in docket 22-03542. Your next, stay in contact with your attorney, Mr. Sarts. Your next hearing will be in circuit court, sir, okay?
I bless you.
All right, thank you.
Thank you.